Sunlight breaks through with a clear headline kind of day, and the story I'm sharing is one that's been sitting with me since the first time I talked about it in 2023. It's the sort of case that starts small, looks simple, and then grows roots in every direction. We're going back to Minnesota to a quiet stretch of private property where a young man set up some targets and did what millions of Americans do on their own land-safe legal practice. Back in May 2022, Matthew Anderson, who goes by his middle name Walker, was 21 and out with a friend in Shelburne County. A neighbor down the road heard the shots and dialed the sheriff. A deputy rolled up, saw that everything looked in order, and then asked to see the rifles. The ARs didn't have serial numbers. Walker explained they were privately made firearms, the kind hobbyists build from so-called 80% parts, and that such guns don't come with numbers the way factory guns do. Despite that, the moment the deputy focused on those blank spots where numbers would usually live, a simple afternoon started bending toward something heavier. 2 felony counts were filed for violating a Minnesota law about unserialized firearms. Here's the heart of why that felt so off. Minnesota's rule says you can't remove or alter a serial number. That's about scratching off or changing a number that already exists. A homemade rifle never had one to begin with, so there's nothing to scrape sand or stamp. In everyday terms, it's the difference between peeling a label off a jar and using a jar that never had a label. Walker's rifles fell into the second category, and that's where the friction began. The deputy's suspicion turned a day at the range into a legal storm. Papers were filed, hearings penciled in, and the simple question, do these laws even apply to a do-it-yourself build, started dragging this 21-year-old through procedures that would exhaust anyone. Think witness lists, motion practice, and calendars that move like molasses. Each time you hope for daylight, another delay slips in. I want to be clear about something without turning this into a classroom moment. When people talk about privately made firearms, they're talking about an old tradition of building a tool for personal use. That's not the same as defacing a government-issued number. One is tinkering at home, the other is tampering with an identifier. Laws are written with particular verbs in mind, and verbs matter. What made this case stick was how ordinary it started. Private land, a friend, targets, a neighbor who didn't like the sound of gunfire. None of that is unusual in rural America. The unusual part came after the deputy asked to inspect the rifles and treated the lack of serial numbers as proof of a crime. From there, a straightforward afternoon tumbled into the machinery of felony accusations, which carry weight far beyond the paper they're printed on. They affect jobs, schooling, travel, and sleep. Through it all, Walker's side kept pointing to the plain words, the state bans removing or altering numbers. These rifles never had numbers. The state kept pressing its reading anyway. The back and forth wasn't just about 2 lines in a statute. It was about who gets to say what the law means when technology and hobby culture change faster than an old paragraph in the books. That tension between the text as written and the text as stretched hung over every calendar entry. It's the kind of pressure that turns months into years, that turns a hobby into a headline, and that makes a young adult feel decades older than the birthday on the license. The opening act of this story isn't fireworks. It's a slow burn that begins on a sunny day and keeps glowing long after the brass is swept up. No one there could know this narrow dispute would tangle with a bigger conversation. Another driver's case, a home-built handgun, and a ruling beyond the county were already forming the legal crossroads waiting a little further down the road. Court dates came and went, but rarely on time. For Walker, it became a rhythm of waiting, checking calendars, and hearing once again that something had been postponed. The charges sat like a shadow, and even though the defense kept pointing out that the law never covered his rifles, the state refused to back down. Hearings were canceled, rescheduled, or opened again under new terms. Judges asked for serial numbers that did not exist. Motions to dismiss were filed, but they lingered on desks as though trapped under paperweights. A simple misunderstanding had grown into a maze of procedure. One attempt to bring in an expert witness showed just how hard the system can push back. The defense wanted someone to explain in plain terms how a rifle built at home isn't the same as altering a factory-made firearm. The prosecution fought to block that testimony. Expert voices can cut through fog, and losing them leaves courts full of speculation. For a young man standing accused, it meant facing not just the charges, but the silence that comes when the clearest voice is kept out. In the middle of this, everything slowed even more because of another case already winding through Minnesota's courts. A few months earlier in February 2022, a man named Logan Vagel was in a single car accident. His vehicle ended up flipped on its roof. While helping at the scene, a trooper noticed an AR magazine, asked questions, and searched the car. Vagel admitted to having a pistol, and what the trooper found was a privately made Glock-style handgun without a serial number. Charges followed under the same Minnesota statute. That case became the test. Walker's hearings were pushed aside until Vagel's journey was resolved. The logic was that a higher court's decision would set the ground rules. While Walker waited, Vagel and his lawyers argued their way through the system. They said the police had no probable cause to search the car. Probable cause, put simply, is a requirement that officers must have a real reason to believe a crime is happening before searching your things. Without it, every encounter could turn into an open search. The district court in Vagel's case went further than expected. Instead of just addressing the search, it looked at the law itself and called it unconstitutionally vague. That phrase means the wording was too fuzzy for ordinary people to know what was legal or illegal. If a law is so unclear that regular folks can't follow it, the court can strike it down. For a brief moment, it looked like the statute might collapse entirely. The state appealed. On appeal, judges reversed the dismissal, saying the law covered all firearms equally. That ruling stretched the words of the statute far beyond what they were ever meant to cover. Homemade weapons, which federal law does not require to have serial numbers, were suddenly being treated as though they were factory products. Vagel's team took the fight higher to the Minnesota Supreme Court, insisting that the law should only apply to firearms that federal rules already required to be marked. While that argument moved forward, Walker lived under constant delay. In April, his family was told nothing could move until the Supreme Court spoke. Bills mounted, stress grew, and the legal cloud darkened with each month. Living under charges is like walking with a weight strapped to your back. You never set it down, not even in sleep. Finally, in August 2024, the Supreme Court delivered its answer. The justices ruled that the statute only applied to guns that needed serial numbers under federal law. Since homemade firearms are exempt, Vagel could not be prosecuted. That decision did more than free one man. It set a boundary for everyone in the state. For Walker, it meant the charges that had loomed over him for 3 years no longer had ground to stand on. The prosecution folded. Citing the Supreme Court ruling, they dropped the case. Relief came, but so did the reminder of what 3 years had cost money, energy, and peace of mind. A courtroom victory doesn't erase the scars left by the process. The conclusion to a long fight rarely arrives with fanfare. It lands quietly, and only later do you feel how much lighter the air has become. After the High Court's decision, the case against Walker fell away not with drama, but with paperwork that finally said what the defense had insisted. From the beginning, the statute never covered rifles that never bore serial numbers. Relief spread in slow waves. It started as a deep breath, then turned into the first good night of sleep in months, and eventually into plans that had been on hold for far too long. There is a difference between winning and mending. The charges are gone, yes, but the cost of carrying them left marks that don't vanish with a judge's signature. 3 years of legal bills do not zero out when the docket closes. Time missed from work or school does not reappear. There is also the quieter toll, the way people speak a little softer around you, the way you learn to read every envelope like it might carry another summons. Victories in courtrooms are measured in orders and citations. Victories in regular life are measured in the return of ordinary routines. The community stepped into that gap. A fundraiser page stayed open, and strangers added small notes alongside their donations. Some were brief, some were heartfelt, all of them a reminder that the story had traveled farther than one county. Crowdfunding is not a cure, but it is a bridge. And in cases like this, it keeps a family moving while the system catches up to common sense. Every name on that list represented another nudge toward normal. The legal meaning of the ruling is simple enough to explain without losing its weight. The court drew a clean line. The state statute applies only to firearms that must have serial numbers under federal law. Homemade firearms do not fall under that requirement. When a law is read past the edges of what it says, courts pull it back. That is not technical trivia. It is a protection that keeps ordinary people from being punished for something the text never forbade. There is also a lesson about process. Cases can balloon because a single assumption goes unchallenged for too long. Here the assumption was that a blank receiver must equal wrongdoing. Once that idea took hold, the machinery rolled forward and was hard to slow down. It took another case, a flipped car on a winter road, and months of appellate briefs to reset the frame. None of that gives Walker his time back, but it does mean fewer people will face the same spiral for the same reason. Stories like this don't come around often, and that's why it feels good to pause and soak in the outcome. A young man gets to move forward, a family can finally breathe, and a state law is no longer hanging like a net over people who never broke it in the first place. It's the rare kind of update that ends with a smile instead of another round of frustration. If you stuck with me through this whole journey, thank you. You're the reason I keep sharing these stories even when they take years to reach the finish line. And if you enjoyed this one, tap that like button so the algorithm gods don't forget about us. Share it with a friend who cares about fairness. Hit subscribe if you're new here, and drop a comment down below. Maybe you tell me how you're feeling about this win. Every bit of engagement helps make sure the next story, whenever it comes, finds its way to you.